In this video, I'll explain why a single Instagram post can now cost creators over $100,000 in trademark lawsuits. And by the end of this video, you'll learn the exact caption words that corporate lawyers are scanning right now. You'll also learn how to protect your brand before the process server shows up at your door. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. For over 20 years, I've defended creators, brands, and business owners against the exact kind of lawsuits that are about to flood your feed. All right, let's dive in. Here's the truth most influencers don't know. The Supreme Court just rewrote the rules, and the bullseye is now on your back. Now, before I get into the courtroom drama, let me tell you who is no longer getting sued. For years, brands went after the platforms. They sued Instagram, they sued YouTube, they sued the internet service providers. That strategy just died. In March of 2026, the Supreme Court handed down a ruling called Cox versus Sony. The court told the music industry something shocking. Knowing that bad things happen on your network is not enough to make you pay. I call this the platform shield. Under this new standard, Instagram and TikTok are almost untouchable. Unless a platform actively pushes users to break the law, it walks away clean. Now you're probably thinking, great, if the platform is safe, then I must be safe too. Actually, the opposite is true. When a deep pocket defendant disappears, the lawyers go looking for the next pocket. And that pocket, you guessed it, that pocket is yours. Now here's the most dangerous myth in the creator culture today. Stop believing that skipping the logo protects you. It does not. Just ask Nicholas Tuinenburg. This past March, a jury handed him an $11 million verdict. His sneakers did not have a single Nike swoosh on them, not one. So how did Nike win? Well, they sued over something called trade dress. Trade dress is the look and feel of the product, the silhouette, the color blocking, the stitch patterns. When a regular shopper looks at your inspired by product and thinks of the real brand, the line has already been crossed. But here's where the case really gets scary for creators. Nike did not just point at the shoes. They pointed at the Discord chats. They pointed at the Instagram captions. They pointed at the hype words. Words like perfect reps. Words like one-to-one. Words like AAA grade. In that courtroom, those words were not marketing. They were a written confession. I call this the Caption Confession. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Now let me show you the 3 phrases flagging you for a lawsuit today. The first phrase is directing language. When you write link in bio for the best reps, you have just induced a crime. The second phrase is comparative confusion. When you write looks exactly like the $2,000 version for only $50, you have written the plaintiff's opening argument. And the third phrase lives in the hidden funnel. Moving the sale to Telegram or WhatsApp will not save you. The Department of Justice is already watching those rooms. And the reason why this is so dangerous is simple. Corporate counsel is no longer hunting the factory in China. They are hunting the US-based creator with a ring light and a Shopify store. That creator is you. So stop assuming that a small follower count protects you. It does not. A single viral post can create enough inducement evidence to fund an entire federal lawsuit. But here's the thing most creators never see coming. The lawsuit itself is the punishment. Let me walk you through what actually happens next. A certified letter shows up at your home. Inside that envelope is a cease and desist letter from a law firm billing $1,200 an hour. 2 weeks later, the federal complaint arrives. The number next to the demand is usually 6 or 7 figures. I call this the Paper Avalanche. The discovery phase is where creators truly break. Opposing counsels subpoena your DMs. They subpoena your Stripe account. They subpoena your Shopify backend. Every post you ever deleted gets pulled from archive servers. Every Discord message you thought was private gets read aloud in a deposition. Your sponsors get tagged into the case. Your payment processors freeze your funds. And when the legal bill hits $200,000, most creators settle. Not because they lost, it's because they ran out of money to keep fighting. That is the real cost of dupe captions. Not the verdict, the journey to the verdict. So what actually works? Here's 3 moves. First, audit your dupe content. Every inspired by post needs a trade dress review. Not next quarter, this week. And second, clean up your captions. Strip out the trigger words. Dupe, rep, one-to-one, AAA. Those words are not clever. They are discovery exhibits. And third, understand curation liability. When you promote someone else's infringing product as an affiliate, the court can pull you in as a contributor. You do not need to own the warehouse, pay the judgment. Now here's what I want you to remember more than anything else. The digital Wild West is over. Platforms are shielded. Creators are now exposed. And the gap between a fun brand post and a federal lawsuit is now 1 caption long. When you adapt your content strategy now, you protect your business. When you wait, the process server protects it for you. Now, if this video helped you see the risk hiding in your own feed, hit that like button and subscribe to this channel and share this with a creator in your life who still thinks dupe is a harmless word. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.